Welcome back, everyone. Joining us now is Andria Ryan, partner of the Fisher and Phillips law firm that specializes in labor and employment issues for the employers. She's also the co-chair of the Hospitality Industry Practice Group. She's going to speak today about common COVID-19 misunderstandings that could place your company at risk. As usual, we're excited to have you with us, Andria, and take it away.
Thank you, Stephen, and thank you all for joining me. We are going to talk in this session, we're going to focus on compliance to avoid liability. We've done a lot of counseling with companies all over the country on handling their employees during COVID-19, and we have really determined what some of the highest the largest number of misunderstandings. And so we're going to focus on compliance to avoid liability. Later, I think tomorrow, you will get to do a deeper dive with my partner, Alden Parker, who's going to talk about some of that, what that liability looks like today. So I'm just going to focus on compliance with you. Number one, the first area, and probably the most common misunderstanding amongst the many companies that we are counseling with, is returning exposed employees to work too early. You know, for so many years, as employers, you struggled with attendance, getting your employees to come to work and stay at work. And now we're having to shift that focus and talk about when to send them home and how long to leave them at home. And so we've become experts at things like contact tracing, so we can send people home. But I think it's very critical that you have someone within your organization or a group of folks within your organization that become experts, and this is a theme you'll hear on the next couple of my slides, and become experts on this issue. If your employee has direct exposure to COVID-19, and there's a specific definition for that, you must send them home. You must ask them to direct them to self-quarantine, and the fact that they go and get a test and it shows they're negative does not control the decision to return them to work. That's a very common misunderstanding. And so we'll spend some time on the deeper dive on this, but the 14-day quarantine period for employees since their last direct exposure to a confirmed or suspected COVID-19 case individual use the 6-15-48 rule. And that is an employee who has been within 6 feet of an infected person or a confirmed infected person for 15 continuous minutes or more within the 48-hour period prior to the sick individual showing symptoms. That's the 6-15-48 CDC guidance. So it's important to follow that rule very strictly. The second most common problem that we're seeing is miscalculating the appropriate quarantine period. They really, along the same lines as not returning exposed employees too early. It's really important to realize that the 14-day quarantine period that I just mentioned does not begin until the last day an employee was directly exposed. So if your employee comes to you and says they have a spouse or a household member that they've been exposed to, and that's where their exposure occurs versus at work, remember they're going back home or they have been in direct contact with this individual for more than just one day or one shift. And so if the employee is exposed to their spouse who is sick with COVID or positive on days 1 through 10, the quarantine period doesn't begin until day 10. So your employee may miss a lot more work than just 14 days. So it's important to be strict to that. Make sure you get enough information from your employee to determine when the last day they were exposed to that family member. One area, and the third misunderstanding, is we're seeing some lawsuits pop up here as well. So this is an important area of compliance. This applies to you as your private sector employer, as most of you are, with fewer than 500 employees. So many of you, and I will say there are some fairly complicated integrated employer tests if you have multiple operations. So I would urge you to seek legal counsel, or certainly we can talk about it a little bit more in a deeper dive as to whether your integrated operations will add up to 500 or whether you want them to for these purposes. This law has been in effect since April 1st, and it stays in effect until December 31st. And so you've got emergency paid sick leave obligations and emergency family and medical leave obligations, even if you are not currently covered by the normal, regular Family and Medical Leave Act. So they operate next to each other, but have different purposes. The emergency paid sick leave is 80 hours of paid leave for 6 reasons. Again, we can talk about them in a deeper dive, but most of those have to do with people that are sick or quarantined or taking care of an individual, a child, a spouse, a family member that's sick. The emergency family and medical leave, it's a little bit misnamed. It is only required for an employee who is missing work for school or because their school or child care is closed or unavailable. So 2 different obligations. Remember, you get a tax credit for these payments. So it's important you have the right documentation in the event of an audit, and you make sure you're taking the tax credits properly. But most commonly, I'm seeing clients that haven't even realized that this obligation applies to them, and they're forcing employees to use PTO or vacation or sick pay for this time off, which the law prohibits as well. So we'll talk about the emergency paid sick leave and the emergency family medical leave acts as well. Let's talk for the next 2 slides about face coverings. Another common misconception is assuming that wearing face coverings trumps, no pun intended, the 615-48 analysis that I just laid out. It does not. The CDC recommends wearing masks. Some states mandate it. You can implement a mask policy even if your state or locality doesn't mandate it. But whether the employee is wearing a mask does not change the 615-48 close contact, direct contact analysis. You should still quarantine any employee who meets that direct contact test. Face coverings will not change that obligation. And the last thing we're going to talk about is something that I know Stephen has gotten a lot of questions about. I've been asked to speak on this topic for numerous groups, and that is handling or mishandling guests who refuse to wear masks. I think it's important that you understand you are permitted to require and should require employees and guests to wear masks, even if your state does not mandate it. It's important to be proactive about how your policy is rolled out to your guests, how often you tell them about it upon reservation, on your website, on social media. Make sure they're not surprised by that requirement. You need to train your staff. Train your staff on how to handle a guest who walks in without a mask, what to say, what not to say. Give them a script. Do training with them that's interactive. Do some interactive role-playing type training, and require your employees to wear the mask and to wear it properly. It'd be hard to enforce with a guest who has, for whatever reason, doesn't want to wear the mask if your employees aren't wearing it properly. Be prepared to reasonably accommodate guests with medical conditions. Remember, your guests aren't going to have usually a copy of their medical records in their pocket, nor do I think you should ask for it. But a guest may tell you the reason they can't wear the mask is a medical condition. Be prepared for a management level employee to discuss with the guest what some alternatives may be to protect them and to protect your employees. And lastly, but probably most importantly, is delicately deal with guests or visitors who refuse to comply with your mask policy. We've all seen enough, the horror stories and the social media and the regular media that shows us some violent confrontations with folks who refuse to wear their mask. It's not a situation you want to put your employees in, and we certainly don't want to get in any kind of physical or verbal altercation with a guest if we can avoid it. So in the deeper dive, we can talk about how to delicately deal with those folks. So we've got a lot to talk about in terms of compliance, and I will end my thoughts here and welcome and look forward to seeing you at the deeper dive. You know, the CDC, everything we've talked about today here, the CDC has given us guidance. It does not have the force of law. And so some ask me, well, you know, if it's just guidance, I don't have to do it, do I? And I said, well, technically you don't, but here's what you need to keep in mind. The CDC's guidance is going to be relied upon as a legal standard. It's going to be relied upon by OSHA, it's going to be relied upon by the courts, by the plaintiff's bar, and they're going to use these standards to say you're negligent if you're not complying with them. And so I think it's important that we as an industry, obviously, and that you as employers hold ourselves to the highest standards and be prepared to defend those, and that we implemented them properly. We held our employees to them, and we held our guests to the standards as well. OSHA is issuing citations under their general duty clause. Maximum penalty for an OSHA citation is over $134,000 per violation. So we're not talking about chump change here. And then of course you have state safety agencies who are getting in the mix as well. So again, compliance is the key. I think it's time, if you don't yet have some designated experts within your organization, experts on contact tracing, experts on your mask mandates, social distancing requirements, capacity limitations, all is going to be important to stay and be in compliance and protect your organization. So I look forward to seeing you at the deep dive.
Thank you, Andrea. Great information as usual, and I encourage everyone to join Andrea during her deeper dive. It's always one of the most highly rated sessions that we have. Andrea, always a pleasure to have you, and we'll look forward to seeing you at the deeper dive before long.
Thank you all. Thank you, Stephen.